usual. And I don't know about Australia. We've got some clients in Australia, whether they're tuning in or not, I'm not positive of that. So our guest speaker has a very wide geography tonight to address.
All good.
About one more minute here. While we're waiting, just a little bit of trivia here. Our guest speaker tonight is a four-time invitee. I don't know if this counts as a fifth time or not when it's virtual. He holds the record for the most times I've had him, and now Matt with speaking at our seminars, live seminars. So this will be 4.5.
Well,
Okay,
I tell you, it's good to be back. That's for sure. We're gonna have some fun here tonight.
we're glad to have you, and we'll make this the start of a new trend.
Yeah.
Iran accepts Pakistan's proposal for waiting.
That's
Okay,
good.
7:02. What do you think, Matt?
Yeah, we can get going.
Okay, I'll just say a few words and you can then introduce Brian. How's that?
Sounds good.
Okay, good evening, folks, and welcome to our April edition of our Matt and myself's webinars. We have a very special guest speaker tonight who's a fifth-time speaker, and he'll be more fully introduced shortly. And estate planning is one of our most popular requests, and we're welcome tonight our guest speakers to continue. I'm going to turn it over to Matt right now for a little preamble for tonight. Go ahead, Matt.
Excellent. Thanks, Daryl, and thank you everyone for joining us on our April webinar. Just a couple of things before I introduce our speakers. So we do have the chat and the Q&A enabled. So if you are wanting to ask a question, please just enter it into the chat or the Q&A, and we will answer all the questions at the end of the presentation. And of course, if there's anything that you don't think of tonight, always feel free to email Daryl or I or Donna tomorrow or in the coming days. We are going to be recording this, and we will be able to post it to our website and Facebook page. So that's another great tool that we're going to be able to provide for our clients. So we're very lucky to be joined by our speakers tonight from Canada Life. I've had the privilege of knowing Wilmot for, I don't know, going on 15, 16, 17 years, and I've seen him speak many times, and I always come away learning something. We're also joined by Brian Pilato, who is the Director of Wealth for Canada Life, and I will let Brian do a proper introduction for Wilmot. Take it away, Brian.
Thank you, Matt. Thank you, Daryl. And just wanted to say thank you on behalf of Canada Life to Tenford Wealth Management for partnering with us and allowing us to come out this evening and speak virtually here. But with that being said, I wanted to take this opportunity to introduce, a colleague of mine, Wilmot George, who will be speaking tonight. Wilmot is an experienced tax and estate planning professional who really understands how taxation and risk can impact wealth. He has over 2 decades of experience in the field, and really he enjoys guiding Canadians on tax and estate planning matters through presentations, one-on-one consulting, media appearances, as well as through written communication and articles. Wilmot's backed by Canada Life's long history of helping Canadians build wealth, and he's really committed to ensuring the protection and accumulation of generation wealth. So, Wilmot, over to you to take it away. Please do ask questions. We'd love for this to be, as educational and informative as possible, and our open arms in terms of collaboration. So, over to you, Wilmot, to take it over.
Thanks very much, Brian. It's an absolute pleasure to be back. I've had a pleasure to work with Daryl and Matt in the past, and when I received the call to participate here again, it was my absolute pleasure to do it. I think these gentlemen and their team are doing a great job for their clients. They understand the importance of holistic financial planning, and tax planning, estate planning is a big part of that. I've had the opportunity to present right across this country from coast to coast, and for whatever reason, folks don't like paying taxes. That seems to be a point of contention for many Canadians right across this country. But the reality is, for most Canadians, tax is a reality. Death is a reality, and tax is a reality. And when it comes to estate planning, we always say that you can either plan for it or not, right? Um, we know that we're all going to pass away at some point in time. So the question isn't so much whether or not we're going to die, although there might be some questions about when that time is going to come. The big question is whether or not we're going to put a plan in place to ensure that our assets get distributed the way we want them distributed, as opposed to being distributed according to provincial law, as opposed to there being conflict after we pass away amongst our family members because there's uncertainty around what should happen to our assets. We can put a plan in place to ensure that everything gets handled as smoothly as possible with the least amount of confusion and conflict as possible, right? So the title of my presentation today is Estate Planning, Managing and Protecting Wealth for Life and Death. Like I said, many folks understand that there's taxation in Canada, but if I ask the question, how many folks understand what taxation looks like at the time of death? A lot of those hands that were up earlier, where folks said, yeah, I understand taxation in Canada, a lot of those hands go down because not a lot of folks have thought about what taxation looks like at the time of death. When we think about estate planning, we often think about the distribution of assets, but we don't think about tax minimization at that time. And if we're interested in tax planning, while we want to be as tax efficient as we possibly can throughout our lifetime, we really do need to take a look at what happens at the time of death, because the truth is, if we're not careful, we could end up paying the largest portion of taxes in our lifetime at the time of death. And I'll explain what that looks like here in a minute. All right, so sit back and relax. We're going to get into this presentation. I'm told I've got about an hour or so to present, so we're going to do that. Be mindful of our disclaimer slide here. And this slide is just telling you to be careful when you listen to me, because everything I'm about to tell you is a lie. Essentially, that's what this disclaimer slide is telling you. No, the reality is this slide here is telling you that the strategies that we're going to talk about here are strategies that generally apply to the masses. However, there's always nuances and unique circumstances for individuals. So when we talk about what we're going to talk about here tonight, understand these concepts at a high level, but before implementing these concepts, talk with Daryl, talk with Matt, talk with your lawyers, talk with your accountants and other tax advisors to ensure that the things that we're talking about here today will apply to your own unique circumstances. All right, so let's get right into it. Our agenda for today, we're going to talk about the importance of estate planning. We're going to talk about taxes and fees at the time of death, specifically income tax and probate fees. And then we're going to talk about strategies for reducing taxes and or maximizing the distribution of assets. And then we got a few slides at the end where we're going to talk about the role of the executor. You see, we know that being named executor, most folks would tell you that being named executor is indeed an honor. Somebody's thought highly enough of you to name you their executor. But it's also a job that carries responsibility and potential liability, risk. It's also a job that can get you into a lot of trouble if you don't take it seriously. So what we want to do towards the end of this presentation is talk about the role of the executor, talk about things to look for when choosing an executor, talk about some of the responsibilities that an executor needs to carry out, and then we'll close out the presentation at that point. All right? Okay, so let's get right into it here. All right. And talk about the importance of estate planning. What is estate planning? I'm sure if I had asked you before putting up this slide, what is estate planning? I'm sure I would get many different answers. Some would say it's writing a will. Some would say it's ensuring we have named beneficiaries on our registered assets. Some would say using joint accounts appropriately to perhaps avoid some probate at death. Some would say having a conversation with family members to ensure that they know what I want done and to clarify any potential conflicts before I go. All of that is estate planning. The true definition of estate planning depends on who you ask. So we have the National Institute on Aging here in Canada, and they wrote a paper called Where There's a Will, There's a Way, Exploring Canadian Perspectives on Estate Planning. And in that document, they defined the estate planning process as the process of organizing one's estate, which is everything an individual owns or owes, and establishing a collection of legal documents outlining how the estate should be distributed in the event of death. They went on to say estate planning also includes establishing how financial and health decisions should be managed while the individual is still alive in the event of incapacity. An estate plan is a written record that sets forth these wishes. So indeed, writing a will be part of that. Indeed, ensuring that you have named beneficiaries on registered plans and insurance contracts can be part of that. Indeed, thinking about how jointly owned property can be effective as part of an estate settlement can be part of that. Having family conversations can be part of that. The process of organizing one's estate, a collection of legal documents. But when we talk about legal documents, we often think about the will as a part of estate planning, but we don't think of power of attorney documents. Power of attorney documents are equally important because many Canadians might get to a place where they're living, but they can't speak for themselves. Who will make decisions for them at that point in time? Power of attorney documents for financial assets, power of attorney documents that governs healthcare decisions. These are documents that you typically draft at the same time as drafting your will. Quite often, estate planning lawyers would encourage you to draft power of attorney documents at the same time you establish your will and review these documents every 3 years or so to ensure that they continue to align with your wishes. All right. But in addition to this, why is estate planning important? By proactively making decisions and taking the necessary steps to ensure one's plans and wishes are clearly known, outlined, and carried out in the event of illness or death, estate planning often provides individuals and their loved ones with peace of mind. Yes, these documents will ensure in many cases that assets get distributed accordingly. Yes, in many cases, these documents will reduce the potential for conflict after death. But perhaps the most important thing these documents do is bring those who create them peace of mind. I'm sure all of you, like myself, have certain things that we know in our mind that we should do, but we haven't done yet. And these things that we know we should do that we haven't done yet, every day we wake up or every few days when we wake up, it's right there at the back of our mind. You got to do this. I got to do this. I got to do this. It's nagging at you. It picks at you until you get it done. Right? So perhaps engaging this estate planning process, putting a plan in place, getting documents prepared, established, aligned with your wishes will bring you peace of mind. So that thing that has been nagging at you for so long can go away, right? So it's important to sit and think about these things just to ensure that things get handled the way you want them handled when the time comes. Now, when you sit down to establish your estate plan, common objectives that folks often consider are providing an inheritance or future income stream for dependents and other family members, maximizing assets for beneficiaries, providing funding for estate expenses, including income taxes and administration fees, minimizing estate taxes and fees at the time of death, controlling and protecting assets after death, and clarifying and confirming one's distribution plan, who should receive assets and how. When you sit down to talk with Daryl and Matt, think about these objectives, talk about these objectives, prioritize these things, because quite often when you prioritize these common objectives, that will define your estate plan. Perhaps control and protection of assets after death is the main priority because you have spendthrift beneficiaries or beneficiaries living with disabilities who can't manage assets appropriately on their own. Perhaps that's the priority, and you'll engage certain strategies to ensure that that priority is met. Perhaps it's minimizing estate taxes and fees at death. Well, there's certain strategies that you can engage there to do that. Perhaps your most important objective is ensuring that your kids don't get in a fight after you're gone about your assets and the intention for your assets, right? Intention you had for your assets. Perhaps that's the most important objective. So prioritize your objectives, and in doing so, that will go a far way in helping to define the estate plan that's most appropriate for you. So when building your plan, consider these steps. Work with your advisors, financial, accounting, and legal to set realistic goals. Determine which tools fit your situation. Is it a will? Is it power of attorney documents? Is it life insurance? Is it a formal trust to ensure that assets are appropriately controlled after death? Is it ensuring that you have appropriate name beneficiary designations on insurance contracts and registered plans like RSPs, RIFs, and TFSAs? There's a number of tools that you can engage to carry out your plan. Choose who will speak for you if and when you can't speak for yourself. We're talking about attorneys for for health and property, power of attorney documents. We're talking about executors for your estate. We're talking about who would be guardians for any minor children in your care. We're talking about trustees for any formal trust that you might establish. Communicate your wishes so that those who need to know what they need to know before you pass away. You can have the best will in the world, but if nobody can find it, how valuable is it, right? Communicate your wishes and keep your plan up to date. People's circumstances change all the time. We suggest reviewing your plan every 3 to 5 years to ensure that it aligns with your current wishes. All right, so let's get technical now. All right, all of that was just kind of setting the stage for where we really want to go with this talk. And I like to set the stage, or I like to dig into taxes and fees at death. Because if we understand what taxes and fees look like at death, then that can help to define our key objectives and the plan that we might build going forward. So like I said, I've had an opportunity to travel right across this country, talking with Canadians coast to coast, and many Canadians don't understand what happens at death when it comes to taxation. And in order to understand what taxation looks like at the time of death, it's important to understand what taxation looks like throughout your lifetime. And this slide that you see on the screen is a busy slide, right? There's lots here. But you don't need to look at the entire slide, okay? On the left-hand side of the screen, your lower and upper limits, those are your tax brackets, right? Your income, your taxable income for the year. As your income increases, you move from one bracket into the next bracket, and so on and so forth. And then there's a column there that says rate on excess. That's the tax rate that applies to each tax bracket. Now, what's interesting about the taxable income, lower and upper limit, and the rate on excess, what's important and interesting about those columns on this slide, there's two things that jump out at me when I look at this table. The first thing I notice is that those who are fortunate enough to have a high income, we'll say the top tax bracket, 258,000 plus, those fortunate enough to have a high income, you're subject to tax at over 50%. 54%, right? 53.53%. So in other words, once you get up to that tax bracket, any additional dollar that you earn beyond that, the government gets more on that dollar than you do. Okay? This is combined Ontario plus federal tax, 54%. And the truth is, almost all provinces across the country, I think there might be just 2 or 3 that have a top tax bracket that's less than 50%. Most have a top rate that's higher than 50%. That just seems to be the way Canada does things. Okay? The other thing that jumps out at me is I realize that throughout an individual's lifetime, they may be subject to lower tax brackets and lower tax rates throughout their lifetime. When they're working in their retirement years, maybe they're taxed at 31%, maybe they're taxed at 23%, maybe they're taxed at 29%, what have you. And then when they die, a large portion of their wealth ends up subject to tax at 54%. Okay? So let me say that again. Throughout your lifetime, you may be subject to tax at 23%, 29%, 31%, maybe even lower than that, right? You may be subject to lower tax brackets, tax rates throughout your lifetime. And then when you die, a large portion of your wealth ends up subject to tax at 54%. How does that happen? It happens because of how the tax system is structured. It's important to note that the tax rules say that when we die, we're deemed to have sold our assets just before death. Let me say this another way. Let's assume that I go out and I buy an asset, and that asset is $10,000, and it grows to $15,000, and I sell it. When I sell that asset at $15,000, there's the difference between its value at the time of sale and what I paid for it is $5,000 gain there. That $5,000 gain is taxed on my tax return for the year that I sold that asset. Let me change the script here now for a minute. Let's assume I buy an asset for $10,000. It grows to $15,000 and then I die. The government says I sold that asset just before I died. So the same $5,000 capital gain that I would report on my tax return for the year of sale while living, I would have to report a $5,000 gain on my tax return for the year of death when I die and have been deemed to have sold that asset. All right. So this is for all of my non-registered assets. So if I have a cottage property, for example, and it's gone up significantly when I die, that gain is taxed on my final tax return, right? I didn't say the same for a principal residence because in Canada we have the principal residence exemption that can shelter that property from tax. But if I've got a cottage property, a vacation property, or I've got an investment property, or I've got stocks and bonds and mutual funds in the non-registered environment in my name, when I die, these things are deemed sold at the time of death, and the gain is subject to tax on my terminal return, unless I'm leaving those assets to a spouse or common law partner. Well, what about RSPs and RIFs? If I've got RSPs and RIFs, maybe I have a $300,000 RSP or RIF or $400,000 RSP or RIF. Well, when I die, unless I'm leaving that asset to my spouse or common law partner or financially dependent child who's living with a disability, and they put those assets in their RSPs or RIFs, these RSPs or RIFs are deemed withdrawn when I die. So a full 400,000, for example, gets added to my taxable income for the year of death. So you can see that my taxable income for the year of death can get very large very quickly and will exceed, in a lot of cases, $250,000 for the year of death, which puts us in the top tax bracket, subject to tax at 54%. Right? So we need to be mindful of that when we're thinking about tax planning and estate planning. But in addition to that, there might also be this thing we call probate. What is probate? Confirmation of an executor's authority to distribute estate assets. I like to use an example. So let's say that I've got this non-registered asset in my name solely. And I have a will. And my will names an executor. Let's say my executor is my brother, for example. And my beneficiaries, as per my will, are my kids. And I've got this non-registered account at a financial institution. It's in my name solely. And I don't know, let's say it's $100,000 as an example. And I die. Well, my brother, who's executor, is going to find my will, and hopefully he knows where it is because I would have told him where my will is. And he looks at the will and he says, okay, he's the executor. Wilmot's got, I know he has this investment account at XYZ financial institution. So he contacts XYZ financial institution. He says, Wilmot's passed away. I'm the executor of his estate. Here's his will. And I would like you to transfer that asset, that account, to his kids as per his will. The financial institution is going to say, sorry for your loss. I know Wilmot, liked him a lot. And I see that he had a will. I can see you're the executor. But because of the value of the account, we would like to see a probated will. So now my brother has to contact the Ontario government, quite often through a lawyer, and contact the Ontario government. Ontario government looks at the will, confirms that it's a legitimate will, puts their stamp of approval on it, gives that to my brother. My brother takes it back to the financial institution, says, here's your probated will. The institution says, thank you very much. That's the protection that we wanted, to confirm that it's a legitimate will, to confirm that you're authorized to distribute the estate assets, and they re-register the account. That's the probate process. But do you think that the Ontario government will put their stamp of approval on that will for free? They don't. They charge a fee. And that fee is based on the value of my estate at the time of death. So if my estate is $50,000 or less than $50,000, there's no fee. If my estate is greater than $50,000, the fee is 1.5% of the amount in excess of $50,000. So just to give you an understanding what these fees look like, if my estate is valued at $1 million, the probate fee is $14,250. If I've got a $3 million estate, it's $44,000 is my Ontario probate fee. If it's a $5 million estate, $74,000 is the probate fee, in addition to income tax payable at the time of death, right? So you can see how taxes and fees can eat up a large chunk of an individual's estate at the time of death and eat into that inheritance that those kids or grandkids or whoever else was expecting to receive at the time of death. Here we have Colleen. Colleen's a widow, has an adult daughter who will receive her assets via her estate upon her death. Among her assets, Colleen has a RIF, the value of which is $600,000. The beneficiary of the RIF is her estate. Upon Colleen's death, assuming a resident of Ontario, income taxes and probate fees for the RIF would be as follows. Income taxes, $321,000 on that $600,000 RIF income. And probate fees, an additional $8,200. And again, that's just in respect of the RIF. If she had other estate assets and other taxable income for the year of death, those amounts would be higher, right? So these are the reasons why we want to sit down and think about estate planning. Most people anyway, folks who don't like paying taxes and fees at the time of death, folks who want to maximize the assets available for their beneficiaries. This is why they want to sit down and think about estate planning so that they can reduce the potential for income taxes, probate fees, and other challenges at that time. So let's take an opportunity now and talk about strategies for reducing taxes and or managing the distribution of assets. I am told by Daryl and Matt, they've confirmed for me that nobody from the CRA is participating in this webinar, so I can talk freely. I hope that that's true. So let's get into some strategies for reducing taxes and or managing the distribution of assets at the time of death. Here is strategy number one, have a will, right? It's a good idea to have a will. 91% of Canadians think wills are an important component of an estate plan, yet only 48% of Canadians have a will. 16% of Canadians believe there are no consequences, or they don't know the consequences of not having a will. Less than a third of Canadians say they have an estate plan. What happens when you die without a will? When you die without a will, you're deemed to die intestate. That's the term, right? You died intestate. There is no will. Some would say, okay, well, what happens when you die intestate? Well, the province decides who will receive your assets. There's a formula for that, right? And in Ontario, I think it's the first $350,000 of your estate goes to your spouse, and any amounts in excess of $350,000 get divided between your spouse and your kids. And some might say, well, that's not too bad. That sounds okay. That's kind of what I would have wanted done anyway. So do I still need a will? Our suggestion is yes. Our suggestion is yes. Because first and foremost, what a will is going to do is it's going to confirm your wishes. That's number one, right? So it makes clear what you want done with your assets. Number two, if you die without a will, you don't have an executor. If you don't have an executor, an administrator needs to be appointed to touch your estate, distribute your estate. The administrator has to apply for that right. That's an automatic probate scenario, right? So it increases complexity and administration when you die without a will. Provincial rules define the distribution as discussed, but these rules may not align with your wishes. Depending on the province, and this is the case here in Ontario, children might inherit directly where the amount exceeds $350,000, I believe is the amount here in Ontario. Children might inherit directly, and this can be an issue for minor or spendthrift children or those who are living with disabilities. Do we really want to put the money directly in their hands? In the case of minors, do we want to have those assets paid to the courts and held for them until sometime in the future? Or should we define a different plan through our will, right? Okay. Like I said, entitlements for minors may require consent from the public trustee to access. And here's the other thing, immediate taxation. If you leave assets to a spouse or common law partner, quite often, those assets are transferred on a tax-deferred basis. So you're deferring tax until the spouse's death at some point in the future. Leaves more assets to the family to grow over time, as opposed to giving it to the tax man up front. But when you die intestate and your children inherit directly, those assets are subject to tax. There are not very many types of assets that you can transfer to your children on a tax deferred basis, right? So these are all things to think about, and why we suggest having a will, even if your preferred distribution plan aligns somewhat with the provincial plan. Here's strategy number 2: draw income in retirement years and consider rollover opportunities at death. Draw income in retirement years and also consider rollover opportunities at death. What am I saying here? Tax deferrals are great, right? We like tax deferrals because it's an opportunity to accumulate assets, not pay tax on those assets as we're deferring assets, as we're generating income, benefit from a tax deferral opportunity. But we always want to do that with an eye to what would happen at the time of death. If we have rollover opportunities at death, it might make sense to continue to benefit from that, tax deferred growth as we're accumulating assets, and roll over those assets to a spouse or common law partner, continue that tax deferred opportunity. So rollovers do make sense where possible, in a lot of cases, not all. But it might also make sense to trigger some income in your retirement years, perhaps more income or cash flow than you might need. Because if you know you're facing a big tax bill at death in the face, then perhaps you want to trigger some additional income in your retirement years while you're still subject to tax at lower tax brackets and lower tax rates. Pay taxes early at lower tax brackets and tax rates in order to avoid 54% at the time of death. Okay, so work with your financial advisor team to determine what makes the most sense for you. If you're staring a significant tax bill at death in the face, it might make sense to try to trigger some additional income in your retirement years, even if you don't need the income, to tax it at lower rates, bump up your adjusted cost basis, and so on and so forth, so that you pay less tax when you die. And hey, if you don't need the cash flow, for many folks, they can reinvest in the TFSA, which grows on a tax-free basis going forward. Right? So you can consider that with your non-registered assets. You can consider that with your RSPs and RIFs. And of course, like I said earlier, if you have a spouse or common law partner, or you have children living with disabilities, then there may be an opportunity to consider a rollover at the time of death to extend the period of tax deferred growth. All right. So you got to really look at your situation and determine which makes more sense. Do I want to take on more income today and pay less tax later? Or do I pay less tax today and benefit from a rollover at death? It all depends on your circumstances. It depends on who your beneficiaries will be. All right. Number 3, name beneficiaries for RSPs, RIFs, TFSAs, and insurance contracts. This is a common one, quite popular, and it's very simple, really. So you've got an RSP, so you got a RIF, so you have a TFSA, perhaps you have an insurance contract. A simple estate planning strategy is listing a beneficiary on the plan contract. When you complete the application or you complete the contract, quite often these applications, contracts, have a place to allow you to name a beneficiary. And if you do that, when you die, those assets normally bypass your estate at the time of death. And when they bypass your estate at the time of death, they're bypassing the probate process. So it can save you some probate fees at the time of death. It can ensure that your beneficiaries receive the assets in a very timely way, as opposed to perhaps getting tied up and delayed in your estate settlement. Okay, so it can avoid the estate for probate purposes. It can provide beneficiaries with quick access to funds while avoiding complex estate settlements. But if you're going to do this, though, particularly for RSPs and RIFs, understand that RSPs and RIFs quite often are still subject to tax at death unless you're transferring those assets to a spouse, common law partner, or financially dependent child living with a disability. If your RSP or RIF is to go to someone else, maybe a sibling, maybe to adult independent children, right? If it's going to any of these individuals, for example, the tax liability for that RSP or RIF at death falls to your estate. And it's important to know this because if the beneficiary named on your RSP and RIF is different than the beneficiary of your estate, you could end up in a situation where the beneficiary of your estate ends up paying the tax bill for the RSP or RIF that went directly to the named beneficiary. And that can cause conflict. Okay, so you want to be mindful of where the tax liability falls as you consider who you should be naming as beneficiaries on your plan contracts. Okay, strategy number 4, be careful with joint tenancy. Be careful with joint tenancy. What am I talking about here? There are many folks who believe that by listing assets jointly with someone else, we can avoid our estate at the time of death and avoid probate fees. And that's generally true. When we're talking about joint with right of survivorship, which is available in Ontario, which is probably the most common form of joint ownership, although I don't have the stats to back that up. But joint with right of survivorship is very, very common. And what happens is if I have an asset listed jointly with someone else and it's joint with a right of survivorship, in theory, when I die, that asset goes solely and directly to the surviving joint owner. It bypasses my estate, so it avoids the probate process and complex estate settlements and so on and so forth. Now, we see this type of arrangement quite often between spouses and can be very effective and useful there. But we've also seen situations where parents want to list assets jointly with their adult children. And that too can work in the right circumstances. But when you're listing assets jointly with your kids, you want to be mindful of some of the risks as well. Some of the risks might include who's going to have signing authority for those assets. Typically, it's everyone must sign together, or you can sign independently. Each one can sign. We can take signatures for either one. Both of those have risks. If both are required to sign, my kids can hold me hostage. If any one can sign, I can show up at my financial institution and have no money one day, right? But also, what should happen with that asset at the time of death? What is your intentions for those assets at the time of death? Let me explain what I mean. Here we have a scenario, an example. We have Tony. Tony's on the left there, blue shirt. Tony's recently widowed. He's got 2 kids, Scott and Kevin. Okay, Scott with the black shirt, Kevin with the green shirt. Now, Tony is getting up there in years. He can't get to and fro like he used to. Doesn't get to the bank or financial institution like he used to. So he leans on his kids a little bit to help him in his retirement years. Now, Scott in the black shirt there, Scott lives not far from Dad, just down the road, sees Dad quite often, every day, every second day, what have you, drops in on Dad, makes sure Dad's okay, and helps Dad with a lot of his day-to-day needs. Now, Kevin loves Dad just as much. Dad loves Kevin just as much. Problem is, Kevin lives an hour and a half away, right? Young family, doesn't spend as much time with Dad. So Dad is thinking, hey, you know what? I'm getting up there in years, can't get to and from like I used to. I see Scott quite often. He helps me with a lot of my finances. I think I should list Scott as a joint owner on my account. It'll allow him to access that money for me whenever I need it, should I not be able to access it myself. So Dad, Tony, has this $300,000 investment account in his name solely. And he decides to add Scott as a joint owner on the account for estate planning reasons and to help him manage those assets while he's still living. I say for estate planning reasons because he heard about this thing called probate, and he heard that, if we list accounts jointly, then maybe we'll save some probate fees. But it's important to note that, Dad is saying this is my money, and Scott will manage it on my behalf until further notice. Now, Dad has a will, and in Dad's will, he says, when I pass away, I want my estate assets to be divided equally between my two kids, Scott and Kevin. I love them equally. I want my estate assets to be divided between them. But Dad makes no reference to this investment account in his will. Shortly thereafter, Dad dies. When Dad dies, Scott contacts the financial institution and says, Dad has died. Here's his death certificate. You could see that I'm the joint owner on the account. Please transfer the account to my name solely. And the financial institution does that. Shortly after that, Kevin contacts Scott. Kevin says, hey, Scott, miss Dad so much. So sad that he's gone. I know you were handling some of his finances for him, and I know he had this investment account, and I'm, just kind of wondering when you're going to pay me my share of that account. Scott turns to Kevin and says, excuse me? I was the one that was helping Dad in his retirement years with his day-to-day, right? Management, helping him with his bills, helping him with his doctor's appointments, taking him where he needs to go. Dad wanted me to have this account to compensate me for my efforts. Kevin says to Scott, you're crazy. You know Dad loved us equally. The only reason you were on that account was just to help him manage his affairs while he was living. You know at death he wanted these assets divided between the two of us. You know that. So now we have conflict. Now we have confusion. Now we have sibling rivalry. Big question is, what did Dad want? Is it reasonable to believe that Dad wanted to leave the money to Scott solely because Scott took such good care of him in his retirement years? Is that reasonable to believe? Is it also reasonable to believe, perhaps, that Dad simply didn't know how joint accounts would be distributed at the time of death, and in reality, he wanted those assets divided equally between his two kids? Is that also reasonable to believe? The question becomes, what did Dad want? We don't know, because when Dad set up the account, he just listed it as joint with right of survivorship and did not clarify or create any additional paperwork to suggest what he wants done with those assets at the time of death. So now we've got warring siblings. What happens next? The siblings contact their lawyers. Lawyers try to resolve it. Lawyers can't resolve it. Where do we end up? We end up in court. What's the courts going to do? Well, the courts would look at past precedent to determine how they should resolve the case. And there was a case, I think it was 2008, if I'm not mistaken, Picor versus Picor, that dealt with this very scenario. And in that case, the judge said, there are two presumptions we should look at when we run into situations like this. Situations where an asset transfers hands without fair market value received in exchange, right? This type of scenario, right? There's two presumptions we should look at: the presumption of advancement and the presumption of resulting trust. The presumption of advancement typically applies when you have two spouses as the joint owners, or you have a parent and a minor child as joint owners. Let's ignore the fact that minor children can't sign contracts for the purpose of this conversation. But where you have a spouse-to-spouse scenario or parent-minor child scenario, the presumption of advancement should apply, meaning that that asset should go solely and directly to the surviving joint owner. Where the relationship is not spouse to spouse or parent and minor child. So for example, where the relationship is parent and adult child, like this particular case, the presumption of resulting trust should apply, meaning that asset should be deemed to flow through the parent's estate and be divided according to their will. So in the absence of any evidence to confirm what dad wanted, in this case, the joint account would likely flow through Tony's estate and be distributed according to terms of his will, which says that any estate asset should be divided equally between the two kids. Why? Because his intention for death were not made clear. The courts have to make a judgment call, and what they would do is just rely on those presumptions that we just looked at, right? So that, you know, a lot of folks don't think about the potential for conflict after death when they're setting up joint accounts. I'm not telling you don't use them. What I'm saying is if you decide to use them, you want to be clear about what should happen to those assets at the time of death, particularly if you believe there's the potential for conflict after death. Okay? All right. What evidence will the courts consider? Documentation, use of property pre-death, taxation, family dynamics, all that stuff. They'll look at all of this to determine which way they should go. But in the absence of evidence, you know, they'll likely rely on those two presumptions we looked at. Okay. All right. In my time, I think I got about another 5 or 6 minutes. I want to talk very quickly about formal trust, and then we're going to talk about the executor, role of the executor, and then we're going to wrap it up. Okay. So tip number 5: consider a formal trust. What is a trust? A trust is a relationship in which a settlor gives property to a trustee who holds the property via a trust for the benefit of a beneficiary or beneficiaries. I have kids. Maybe my kids are spendthrifts. Maybe my kids are living with disabilities and can't manage money appropriately. Maybe my kids have creditors and I fear putting money directly into their hands for fear that those assets will go to creditors. To manage those situations, I can set up a trust. I can set up a trust while I'm living and put the money in there, or I can set up the trust at the time of death. That's a testamentary trust. Okay, trusts are not typically used for tax savings. You wouldn't consider setting up a trust to save taxes. Because the truth is, any tax benefit that you would get through a trust, you can get without the trust in most cases. The reason folks consider trusts is if control is desired or required once that asset is gifted away. All right. So it might work well for spendthrift beneficiaries. Instead of giving my son $100,000 up front when a shiny red sports car would show up in the driveway the next day, I can pay $10,000 from the trust each year for the next 10 years, for example, to ensure that that money is used properly, right? I can set up a trust for beneficiaries who are living with disabilities. I can set up a trust for minors or young adults who are not able to appropriately manage money. I can set up a trust if I'm concerned about creditors that my kids might have, or grandkids or anyone else, okay? So that's when trusts are typically used. It may be appropriate in your situation. I'm not gonna go over all the advantages and disadvantages. You can speak with Daryl and you can speak with Matt about the advantages or disadvantages, but it may be appropriate in your situation, okay? All right, let's talk about the role of the executor. I think about another 5 minutes or so. Let's talk about the role of the executor. Executors are expected to carry out their duties in the same way a prudent person would manage his or her own affairs. They must act honestly, judiciously, and in the best interest of all beneficiaries. In other words, I should not take over the role of executor or take the role of executor and be negligent in that role. If I take over the role or take the role of executor and then turn a blind eye to the market and the value of the estate plummets, I can become liable for that. If I take over the role of executor and I look at who the beneficiaries are and I say to myself, well, I like 2 of the 3 beneficiaries. The other one, not so much. So I'm going to manage this estate in a way that favors the 2 of the 3. I can't do that. I got to be even-handed. Okay? So executors who do not comply with managing the estate appropriately, honestly, judiciously, in the interest of all beneficiaries, it can result in personal liability for the executor. So executors should avoid conflict of interest, act reasonably when exercising discretion, protect the state assets from significant losses, and treat all beneficiaries fairly and objectively. It is a job. It carries a lot of responsibilities. Making funeral arrangements, taking an inventory of and securing assets, filing for probate, advertising for creditors, filing the final tax return, and any estate returns if the estate is open for an extended period of time, paying debts, including income taxes, dealing with challenges to the will, accounting to the beneficiaries, distributing the assets eventually, and keeping accurate records in case challenged. That's a lot. And not all estates are simple. Some are complex and can take time to settle. So you want to choose somebody who's has the time, right? Somebody who's responsible, right? Sometimes your spouse might not make the best executor. Sometimes your oldest child might not make the best executor. Sometimes you might want to have multiple executors. We often suggest 1, 3, 5, 7, 9 as opposed to 2, 4, 6, 8, 10. Although if you are going to go with an even number of executors, you want to talk with your lawyer about how to break a tie if the executors disagree on something and how to carry something out. You don't want delays in the settlement of your estate because the executors can't agree, right? In preparation for the role, executors should sit with testators to review the will and understand wishes, determine the location of key documents, identify and discuss funeral preferences, suggest a list of assets and liabilities where person who is writing their will, naming an executor, leaves a list of assets or liabilities. It can make it a lot easier for the executor when the executor needs to carry out that job. And sit with testators to understand the role, duties, and obligations. Okay? So that's a very, very brief discussion on the role of the executor, but we thought it important to include that in this estate planning presentation. All right? Good. So I'm going to stop there. I think I said a lot. I hope that you guys got something from this talk. My goal was to stir you up a little bit, get you thinking about a few things. I hope I've done that. I'm now going to turn it back over. Who am I turning it back over to? Daryl or Matt? Who am I turning it over?
Well, I'll take it, Wilmot.
All right. So why don't you
right.
take over and set us up for what's next?
Absolutely. Thank you very much. Great presentation as always. If anybody has a question, please feel free to put it in the chat or the Q&A. And while you're thinking about questions, I'll ask a quick one, Wilmot.
All right.
You talked about trust and possibly if you have a disabled child or a child you're thinking about may spend that money quickly. So that is something that we come up with clients a lot. Would you have any other suggestions other than a trust, which can sometimes be a little bit more complicated than people want to dive into?
Yeah, I think it really just depends on who the beneficiary is, right? Because if the beneficiary is a minor, right, then perhaps what you do is you just say, look, I'm going to name my sister, right, as a trustee of this asset for my minor child, right? So there are situations where as opposed to setting up a formal trust right? And perhaps incurring the expenses associated with setting up a formal trust, where you can spell out some specific instructions regarding the use of that asset. Maybe it's a scenario where you're saying, look, I trust my sister to use their discretion. I'm just going to leave the assets to my sister in trust for, my minor child, and give my sister the discretion to kind of pay out the asset when she sees fit, right? There are some situations where you might need this formal trust. There's other situations where, we've seen people set up in trust for accounts for minor children. And then when the child reaches the age of majority, then they can gain full access to those assets, right? So I think it really just depends on the circumstances. But what I will say, though, is I will say if you want specific instructions for these assets over an extended period of time, and you want detailed instructions over how this money is to be used, I would incur the expense to set up a testamentary trust, a formal testamentary trust, to ensure that if anybody challenges your use of those assets going forward, there are clear instructions around how those assets should be used, right? So I think testamentary trust doesn't have to cost a whole lot of money. What we're talking about is including an extra provision in your will to set up a testamentary trust at the time of death, right? So, this doesn't have to cost thousands and thousands of dollars for a testamentary trust, right? It may just be a couple $100, to include an additional provision in your will. It really depends on the lawyer that you're dealing with. But I wouldn't shy away from going with a formal trust if you've got, beneficiaries living with disabilities, and they'll require use of this money for an extended period of time. I wouldn't shy away from using a formal trust for minor children, even if I don't want my minor children to receive these assets at 18. Maybe I don't want them to receive these assets until 25, for example, or 30, or put conditions on this money, right? Around school and so on and so forth. Then I would go to a formal trust, and I wouldn't try to avoid the costs associated with it.
I would
Great.
agree with you that, Wilmot. We're in a couple of the office here now with trusts that were set up a few years ago. Instructions were not clear.
Right.
And even the person kind of looking after it was not one of the trustees, and we're not actually adhering to the terms of that trust. So I would agree
Right.
100%. More
Yeah.
formal, the better. When money's
That's right.
involved, more formal, the better.
Yeah. Yeah, I would suggest that for sure.
I also want to say tonight, really appreciated how you focused on the possible tax savings with a bit of ahead planning. So for a guy that's made his living on tax brackets for almost 40 years, that's kind of our forte here, is the more planning you do ahead of time, because tax savings are considerable. So kudos to you. A great presentation.
Yeah, my pleasure. My pleasure. Yeah, it's important just to know this stuff, right? A lot of folks just don't know this stuff.
No.
It's important to understand what happens at death, because if you understand what happens at death, then you can think about what you want to do to manage that situation. But if you don't know, you don't know. There's a lot of people who pass away and they walk right into huge tax bills because they just didn't know that that's what happens at the time of death, right? And their family is left with this large tax bill. So, look, step one is joining a webinar like this, so that you can understand what happens at the time of death, and then step two is to reach out to you guys, Daryl and Matt, to talk about how to manage taxes at death and other estate planning objectives, to ensure that you get peace of mind through the establishment of an appropriate plan.
Yes, and one thing Matt and I have done increasingly the last few years is people have accumulated far more in their some of the registered investments, facing that tax liability at death. We have turned to life insurance, which I think is, as far as I know, Wilmot, still the most tax efficient way to transfer money to the next generation on death is life insurance. Is that correct?
Well, look, life insurance is awesome, right? Life insurance provides flexibility. Life insurance preserves an inheritance, right? Life
Yes.
insurance can preserve assets. Consider the situation where an individual does have a vacation property, and perhaps this vacation property has been in the family for years, generations, handed down from one generation to the next, to the next, to the next, right? So here I am, I inherit this vacation property that's been in the family for generations. I inherited it, maybe 25 years ago, and the fair market value of it 25 years ago, I don't know, maybe 50,000, right? Today it's 400,000, right? So there's a large capital gains tax liability there. But I never thought about taxation at the time of death, right? And then all of a sudden, as much as I want this cottage or vacation property to flow to my kids and stay in the family, I never thought about the tax liability at death. So all of a sudden now I die and there's this big tax liability there. I want my kids to receive this property, but that property can't be registered to them until all taxes are paid. We don't want to sell the property to pay the taxes because we want that property to pass down to the next generation. Well, how are the taxes going to be paid? Who has the money to pay the taxes? Does the estate have other assets to cover that tax bill or not? Maybe not, because we didn't think about the tax bill on this property. Did I buy life insurance to extinguish the tax bill so we can preserve this property for the next generation? Right? Life insurance has its place. It can preserve assets. It can preserve an inheritance. Where we can't get away from the taxes, life insurance helps to extinguish the taxes so we can preserve assets, right?
I'd agree, Matt. You can add in one of your original comments when you started, Wilmot, was people don't apparently like to pay taxes. I've never heard that once in 40 years here, so that was illuminating to start with. But you're right. If there's a property that is not actually sold, only deemed to be disposed of to a family that wishes to preserve it, where's the money coming from?
Right.
So you're preaching to the choir, and hopefully our clients and people on our webinar tonight think of that in case it affects them.
Yes, indeed.
Matt, anybody at all for questions?
None at this time.
Hopefully our chat or our question is it working tonight, I hope.
It says it is.
Okay, good.
You might get some after too. If sometimes folks are shy, you might get some questions after. And if you do, you guys know where to find me anyway. So
where else could you get questions answered for free from accountants and experts here? So please, folks, don't be shy about writing in a question.
Maybe you guys do such a great job with your clients that you got everything covered.
We hope.
We try.
Okay, Matt.
Yeah, well, I guess no questions for now, so I guess we can end it here. And Wilmot, great presentation as always. Always a pleasure to see you present. Can't wait for the next one as well. So hopefully we'll get you out in person in the near future.
Yeah.
Yes, and Brian, thanks very much for sponsoring Wilmot tonight. Wilmot, if you're in the area, we hope you come into the office and see you in person here. We'd love that.
Well, I'd love to do it. We'll lean on Brian to get that set up, and we'll do that one of these days.
Yeah, and we may well do a live presentation too. I want to see how your energy was first, but you certainly didn't let me down. What a pleasure.
All right. Well, thank you very much, everybody, for joining us tonight. We're putting together our May webinar, so we will let you all know the details of that one when we have it all confirmed. And please, if you have any questions, give us a call tomorrow or in the coming days. And we can always get questions to Wilmot or Brian and see what get you the answers back. All right. And yes,
so one last thing. I see we have a question, Matt, and I do believe that Wilmot would be able to give the slides to the good folks on here tonight.
Brian has a copy of that. I'll leave that, Brian, to get over to you guys, and then I have no problem. You can get that out.
Great. So anybody wants to email us, we'll make sure we get you a copy and we will post. So thanks so much, Wilmot, and you too, Brian.
Perfect.
My pleasure.
Thanks, guys.
Thanks, guys.
Take care.
Good night, folks.
Bye-bye.